because of the lack of having the wedding, then in that case, the recipient of the ring gets to keep it. But if it's the recipient of the ring who causes the breakdown in the relationship and thus prevents the marriage, then the donor can receive the ring back. There is case law.
Right. And, you know, from a practical point of view, if you're sitting there as a judge listening to a case like this, whether it's relevant or not, that's going to play some role into how you may find legally as to what went on in this thing. I mean, if a person is, if you can establish a pattern of someone getting engaged and keeping engagement rings, you might get a sympathetic judge.
Yeah, that sounds right too. So again, before we speak about the prenuptial, what about an engagement has happened, there's the ring, the couple begins to plan. Now there are photographers, there are banquet halls that presumably the couple have entered into together. Presumably they went to visit the photographer or the banquet hall to discuss what food was going to be, what music was going to be selected, etc. What happens with that? And then what happens if the bride-to-be has selected the gown, it's just the bride-to-be, and she's invested in that? What happens in those cases?
Well, usually with, when you're engaging the services of photographers, wedding hall, banquet hall, most places will have you sign a contract, and my understanding is that there's usually an early termination clause in the contract, so whatever deposit you give, you forfeit. And the closer you get to the wedding date, the more you forfeit.
In fact, there's an important thing to note here, because we actually have had quite a few cases like this, believe it or not. A lot of different ways of looking at this from different points of view. Who signs the contract? The husband-to-be, the wife-to-be, the parents of the wife-to-be? Whoever signs the contract is the person that's going to be responsible for the terms of the contract. If I were advising a bride or a husband-to-be or the parents of either, and they're going to be the ones to sign the contract, make sure there's language in there that limits your liability on what would happen if for some reason the wedding doesn't go forward. And many times all that the person who you've entered in the contract is entitled to is the deposit. And a lot of times, as Jackie was saying, the deposit actually is a certain amount at some stage, and then as you get closer to the wedding, it's more and more. What that does is it protects the provider, the caterer or whoever, because they booked off that date to use. Now, if you cancel it 4 months in advance, 3 months in advance, they might be able to fill in that date. If you cancel it a week before, they're probably not. So that's why that works that way. But make sure your liability is limited in
I
the
will
contract.
say this, too. The loss that you experience in canceling a wedding is far less than the loss an individual would have in having to get divorced.
Okay.
Because of the legal costs.
Well, that's...
But that doesn't mean, you know,
okay.
No, just point that out.
Yeah, it's a good point.
Just point that out.
Once people start, once there's not love, there's money. There's always the money. Do people actually start thinking, I gave $100 for this deposit, you gave $100 for that deposit, and then start figuring out how much they each gave and then take to court the issue, I paid more, you paid less, let's even it out? Do those things become court issues?
You're reasonable about it.
Yeah,
Maybe.
you do see some of that. So that would be a small claims issue usually.
Okay.
And so the prospective husband brings the prospective wife to court because he paid $3,000 in deposits and she paid $2,000 and he wants $500 back. That's a small claims issue between the two of them. The bigger issue usually is who's paying that third-party provider and what are they responsible for on the breakup.
Yeah.
Well, I guess this is the time to start talking about prenuptials. Apparently, it's not just for those who are very wealthy.
No.
Explain what a prenup entails and who should be doing it.
Okay, I'll start with Rhode Island. In Rhode Island, there's a statute that talks about a prenuptial agreement, and it basically says that if you give full disclosure to the other side of all your assets, you can protect assets that you had prior to the marriage. Now, there's a lot of different issues that go into the prenup. It's not just about if I get divorced, what am I keeping, what am I giving up? It's also what if I die?
Yeah.
And
Inheritance rights.
Inheritance rights and other things that you may not even think of that could go into there, such as, let's suppose, for example, the husband had a business with his father or mother or whatever, and it was going to grow, and eventually he was going to get that business, but he wasn't going to get the stock until during the marriage. You can provide for how that will be distributed upon a divorce or his death. If he had a house before, is he going to let the new wife live in the house for as long as she's alive if he were to die, or what? There's a lot of different ways of crafting a prenup. It's only as limited as your imagination.
Massachusetts has a similar statute, but let's be generic about it. With all states, a prenup has to be in writing. Because it's a contract that involves a contemplation of marriage, it has to be in writing. Any contract should be in writing. But for a prenup to be enforced, it should be in writing. It should be signed by both parties. It should be witnessed. It also should be notarized. And the key elements of a prenup, number one, it has to be fair and reasonable. You can't put something in a prenuptial agreement that is unreasonable. For instance, wife, you have to iron my socks 20 times a day. That's not reasonable.
Who said?
Yeah, who said? That's usually for the husband to do, right?
Okay.
It has to be fair and reasonable. It can't be void against public policy. You have to make full disclosures of your assets and your liabilities. Without those disclosures, you have a vacant document, because the whole purpose of signing a prenuptial agreement is to disclose what your net worth is. If you do not make disclosures, later on if there's a problem and the court determines that an asset was not disclosed, well, number one, you've committed fraud,
Yeah.
and number two, you risk losing the asset.
And the agreement can be set aside by the court, because you can give away the farm, as somebody we know likes to say,
Exactly.
but you
Yeah.
have to know what you're giving away. And that's the whole point of having full disclosure. I might not have made the agreement that you and I entered into had I known X, Y, or Z existed, more assets,
And what is a
whatever.
full disclosure? It's simply, the way I handle it is, you have to give me information, or the individual has to give me information about their assets. Give me a bank statement. Give me a stock statement. Show me your IRA accounts. Show me the house. Show me the value of the house. Now your liabilities. Give me a copy of your credit card bills. Give me a copy of your mortgage statement. That is all included in your prenup, and that's how
Right.
we ensure that it's going to be
We
a
set
valid
those out as a
document.
schedule at the end
Exactly.
of the document.
Exactly.
Well, while you're speaking of prenups, and you mentioned earlier, David, that if a father and son had a business and you wanted to make some provisions for that, wouldn't that have been considered a non-marital asset anyway, so that it wouldn't become part of that marriage, so that you could
Well,
squabble about it later?
What I was suggesting is, what if the father and son have been running this business together for 10 years, and the father and the son have agreed that the son is going to buy over the next 10 years his father's interest in the business?
Then it becomes part of her money, their
Exactly.
money.
Yeah.
Right.
Fair enough.
The other important part of a prenup is you have to keep your assets separate. Because if you take the assets that you want to remain separate in your prenup and you commingle it with the spouse's assets, now you've taken a non-marital asset into a marital asset. It's called transmutation. So forget about it now. You've commingled it. If you
Right.
put someone's name on a bank account, you put someone's name on a deed, now you've commingled a non-marital asset. That becomes part of your marital estate, and that's going to be distributed in a divorce.
Right. And what you can do, and what we often do a prenuptial agreement is usually done to give you the parameters of what you can do to protect your assets. It does not mean, and I think sometimes people get a little confused by this, that down the road, you've been married 4 years, 10 years, 20 years, you have to follow the tenets of what's in that agreement. You can change assets, and you can say, we've been married 20 years, we've been in the same house, you've contributed to it, I'm putting your name on the house. It doesn't mean the prenuptial agreement says you can't do that. You can do whatever you want subsequent to entering into the agreement in the first place.
Now, as you're talking about reasons that people might do that, I also see plenty of this online. Is there such a thing as prenuponline.com, where people could actually take care of such a thing as a prenup themselves? I'll tell you yours, mine, you tell me yours,
Yeah.
we'll sign
Here
it
we
when
go.
it's-
Yeah.
It's,
You
the
can
person
do
who
anything
represents
online.
themselves
Right.
as a lawyer has a
Right.
fool for a client. A valid prenup has to be witnessed, has to be notarized. And a matter of fact, in this case law that says you should get legal advice. I'm very strict about that. If someone comes in my office, I write the prenup for them, and the other party chooses not to get an attorney, I'm going to write that throughout the document. advise to get an attorney.